Catherine, you should be able to speak now.
Okay, I'm sorry. So I'll start over. So as Patrick mentioned, you had a memo from me highlighting some of the main points of how you do your job, including quasi-judicial hearing matters and open meetings. I'm going to talk just briefly about those points so as not to bore you with this very exciting topic. So just kind of an overview. The city generally does two things: legislative actions or quasi-judicial. As the Board of Adjustment, you are only involved in quasi-judicial matters. So you don't have any legislative powers, so I'm just going to focus on that. There's a couple of items within that umbrella that are important for you to know when you have an application in front of you. And the first one of those is making sure you're applying the law to the facts. And that's basically applying the criteria of the code, which, you know, Patrick lays out in his staff reports. The staff reports are really good. They're a good tool for you to rely on. And applying that to the facts of the application before you. Now, you may have personal feelings about the application or have outside information, which we'll talk about a little bit later, but you're really there to apply the facts to the law to the facts of the application. And sometimes that can be really hard because let's say someone asks for a variance and, you know, they have to meet the hardship criteria and they just don't meet it. But you think common sense says, well, that should be approved. Well, unfortunately, common sense isn't one of the criteria. And so until council changes that, they're going to have to meet that hardship. And it comes up a lot in variances. I use that example because this almost constantly comes up. Very few people will meet that hardship criteria. And so you're going to be denying a lot of applications. That's kind of just the reality. So it's really important that each time you do take that criteria and you apply it to the facts in front of you. The second part is ex parte communications. So like I mentioned, you can have personal knowledge of a situation. You live in a smaller community, you know, a person might be down the street from you whose application is in front of you, but you can't gain information about the application outside the hearing with the intent to do so, basically. So you can't communicate with the applicant, proponents of the application, opponents of the application, anybody in the public, basically, you shouldn't communicate with on the application itself. You can simply say, you know what, if I talk to you, I might have to recuse myself, and then whatever you're convincing me to try to do, I won't be able to do. And so that's one way to kind of get out of those conversations if that happens. It probably only happen if you had a really controversial application in front of you, which I don't think has happened in my time at Canyon, but is always a possibility. So you can discuss things with staff with, you know, if you have questions and you want some answers from Patrick, he can do that for you. The best practice is for him to provide that clarifying information to the whole board so they receive the exact same information, or he could present that at the hearing. Next is the conflicts of interest. And this may or may not come up in your role as a board member of the Board of Adjustment, but if for some reason you had a financial or personal conflict or interest in an application, you should disclose that to the first person is to talk to Patrick about it. And if Patrick has concerns, you can get on the phone with me and we can just talk through what that is so we can decide whether or not you should recuse yourself or not, and whether or not your conflict or your interest results in the appearance of impropriety or that you won't be impartial to your decision making. Now, of course, you are one of a body of decision makers, and so that has to be kept in mind when we're talking about those conflicts of interest. And so we're really looking for items that are, you know, direct conflicts, like you will get a monetary windfall if this application is approved or if the application is denied. And so those are the things we're really looking for. But there are sometimes smaller things like, you know, maybe your cousin is the applicant, or, you know, a close family member is the applicant. And so it's best if you have any questions about that or you're feeling uncomfortable, just go ahead and give Patrick a ring, and we can talk through it if you need to. We may advise you that you need to disclose it, just to maintain the impartiality of the board, and maybe you don't need to recuse yourself, sorry. If you do recuse yourself, you will need to obviously leave the room. I know one day we'll have in-person meetings again, but I guess leave the Zoom meeting right now and not try to influence the vote in any way. That's a lot harder to do on a Zoom meeting, but typically we don't want you like in the back of a room, like, you know, making signals at the other board members regarding your feelings on an application. So, and the last component of that is prejudgment. So you want to make sure that whenever you go into a quasi-judicial hearing, that you are avoiding any kind of prejudgment. Now, again, you may have personal feelings, but you really have to keep an open mind and absorb the testimony and evidence that is given to you and make an informed decision, again, applying that criteria to the application and doing that with an open mind, even though you may have personal feelings about the application itself. And so you want to avoid any appearance of prejudgment. And so, you know, you don't want to say things like, well, I don't think we should even hear this testimony because it's not important, or something like that. So not that anyone would ever do that, but just kind of avoid those kind of indications that you've prejudged an application. Any questions on quasi-judicial hearings or anything like that?
No.
Okay. The second component is open meetings, and I'm going to talk a little bit about open records as well, although it's not mentioned in my memo. So any meeting of the board with a quorum or 3 or more members is subject to public notice. So basically you cannot meet without public notice, and that public notice has to be timely and informative. So it has to be, the law currently states 24 hours before the meeting, and has to explain what you're going to discuss or what decisions you're going to make. So a meeting also, by its definition, includes electronic meetings. So this would include email, text messages, anything like that. And we've had some recent cases come down. They're only district court cases right now, but we suspect that the law is headed, definitely headed in this direction, frankly, is that some very disfavorable cases with council members discussing legislation, discussing applications by email with each other prior to a hearing or a meeting on them. So the court found that those were meetings in violation of the open meetings law. In addition, we take the position, and most municipal local government lawyers take the position, that any kind of round robin email is also a violation. So if one board member sends an email to a second board member, that board member sends it to a third, that's essentially the same as having a public meeting without notice.
Quick question.
Yeah.
Sorry to interrupt.
No, absolutely.
If you're simply discussing an application outside of the meeting with another member of the board, is that in any way a violation of laws or protocols?
So it's not if it's only one other board member, it's not technically an open meeting violation, but we would discourage it as much as possible because it is somewhat of an ex parte communication, and you could develop some prejudgment based upon that conversation. So we would recommend trying to avoid it. We realize it happens, but as much as you can, I try to avoid conversations like that. And if you do talk to another board member, and let's say the board member says, well, I've got these questions, like, what do you think? Maybe the best response to that is, let's talk to Patrick about it. Let's talk, let's talk to him about it, and bring that staff member into that conversation so you can gain information. And I think board members just need to be cognizant, like, am I leading myself down a path of making a decision before I get into the hearing? And if you think that's kind of what's happening, like you start discussing like, well, I think we should approve this, or I think we should deny it, I wouldn't have that conversation. But if you're just like, I don't understand this, or I need more information here, I think those conversations are probably okay, so long as they get then steered back to staff to give you what you need. I mean, ultimately, like you're the bosses for these hearings. And so if you don't have what you need to let us know so we can get it to you as much as we can.
Understood. Thank you.
So one other component, and I think I saw Patrick mention this in an email to you guys talking about emails again. So if you have an email communication that's maybe a violation of the Open Meetings Law, but even if it isn't, and let's say you're discussing an application with another board member and you're using your private email, those are public records. And so if you're using your private email, that's why we want you to have city emails, and it sounds like they're working on that. So you can keep all your city business separate from your private business. And this is unlikely to happen, but if the city were to get an open records request regarding some kind of decision the Board of Adjustment made, and it asked for all the emails, we would potentially have to go through all your emails to make sure that we get all the documents in response to such a request. And I don't want to dig through your private emails. You don't want me digging through your private emails. And so that's why we like to keep those things separate. But one thing to keep in mind is if you are talking to anyone really from your city email or talking about city business, those are public records. And so just be careful about what you say. Things can get interpreted differently when they are read on a piece of paper as opposed to when they, when tone is gone or you're talking to someone who knows you really well. Those things can kind of change when they're just read on a piece of paper by a stranger. So be careful about what you put in email. To the extent you can, I would steer clear of it, to be honest. So that's just a little open records information too that wasn't in my my memo. So, and that's pretty much it. I'm happy to answer any questions on any of that.
Let me just add something about those private emails. We do, in fact, have them set up. If you're not already using them, I can put you in touch with Elijah Owens, and he can walk you through how to access it, how to set it up so that it sends your private email an alert that you've gotten a new email in your @canyoncity.org email account. And it isn't just open records requests. An even more dire situation would be if the Board of Adjustment denies a particular application and the property owner decides to sue. At that point, as part of discovery, your email accounts would be subject to review by the court. So I think it's obviously a very good idea to get into the practice of when you are acting as a representative of the Board of Adjustment, use your canyoncity.org email accounts. That's what they're there for, to protect your private emails. Any questions for us about that?
Patrick, this is Randy. I don't have a problem with that because that's what I've been using. As of late, though, and I might have to talk to Elijah or someone, I've been getting these, I'm not sure what to call them. They're considered like spam folders or something like that. It comes through and says, do you want this to be released to send to you? So it's kind of like they're policing their own email. And
yeah, so what that email is a spam filter alert. We get one here at work every morning, and it tells us that certain emails have been held because they don't look correct, they're suspicious in some way. And you've got the option when you get that to either say, oh, this is an okay email, I know this person, that can be forwarded, or you can selectively delete them, or you can do a mass deletion of everything that's there. And that's generally what I do. What I find is that what's in my spam filter is just not stuff I'm interested in potentially infecting my computer with. So that's what's going on. But if you've got any questions, you should definitely give Elijah a phone call about that.
Yeah, the interesting thing is the ones they're trying to spam or filter are the ones I'm getting from you guys. So it's kind of like it's a vicious circle. They're spamming your own emails.
You can instruct that to always allow those emails. Elijah can walk you through that process of how to educate the spam filter to know these are valid emails and I want you to let them through every time.
Okay, yeah, I thought I've done that because you can put them on a white list or some other sort of list, but if it comes up again, I'll ask Elijah. That's all, no big deal.
Okay. And Chris, if you have not already set up your @canyoncity.org email account, I can get you Elijah's contact details, and you can have a conversation with him, and he can walk you through how to do that, either on your home computer or on, you know, your mobile phone, some sort of an electronic device.
Thank you. It's set up. I'm not very active at looking at it yet, but I'm not sure what that was. Did you hear me though?
I heard that it was set up and you were receiving alerts.
Yeah, it's set up. Thank you.
Okay. Any other questions about Catherine's presentation on conflicts of interest?
No, Catherine always does a good job with such a enlightening subject matter.
Is this your second time, Randy?
Third, I think.
Third. Wow. Ooh, sorry.
That's okay.
Very important.
Okay. I do have a presentation as well, and I don't know, are you all, do you have your computer screens in front of you? Because I have a PowerPoint to show.
Yes, I see it.
Yes.
Okay, so let me start this. We're going to talk about Board of Adjustment and specifically variance practices in Canyon City. There is a little bit of overlap between what Catherine just explained to you and what I'm going to explain to you here, but because I kind of go in a different direction with this, hopefully this will provide a bit of a broader context for variances and what we do with them, and you know why the public hearing process is kind of very important to all of this. So let me begin talking a little bit about the overall land development review process in Canyon City. Basically, from the Board of Adjustment's perspective, there are two different kinds of land use processes that you pay attention to. The first is zoning. This establishes the rules for use, height, and bulk for all development parcels within the city of Canyon City. That either happens as part of an original annexation and zoning or as part of some sort of a rezoning effort. All the other land use application types, whether we're talking about subdivision or site plan, these need to confirm that the development of a parcel is going to conform to the rules of zoning as well as to unique development standards that are applicable at the time of subdivision or site plan. Now, variance requests occur when a conflict exists between the zoning and the subdivision or site planning of a parcel. This conflict has to be of such a degree that strict conformance to the requirements of zoning or the development standards of the parcel would render the parcel near undevelopable. Now, what I'm showing in this image is the most recent example of a variance that came before the board. You'll recall that we had that parcel on Candlewood Drive where they were seeking to get relief from a setback requirement. And I'm not trying to pick on this particular project, but I chose these images just because this was still relatively fresh in everyone's minds. Now, the American Planning Association defines variance as a request to depart from the literal requirements of a zoning ordinance. This can include relief from setbacks, height limits, parking requirements, landscape requirements, some other specific performance requirements. Some jurisdictions have lighting and photometric requirements. Some jurisdictions have specific building materials requirements. It can get as onerous as the zoning allows it to be. Now, the asset test for variances, and this is a point that Catherine made, is the existence of a hardship. Hardship cannot be measured in financial terms. Someone saying that they don't want to, provide 100 parking spaces, which the zoning might require, just because it's too expensive to do 100 parking spaces, that's not grounds for variance. That's someone self-inflicting that, okay, I want to build this huge building and then underpark it. That's not a reasonable variance standard. Now, items that do potentially qualify as hardships include undersized lots, lots with an unusual shape or topography, lots with a significant historic resource, historic structure on them, lots with protected wildlife habitat or areas with unique vegetation that are considered an open space resource that we want to preserve. Those are potential reasons for saying, okay, strict compliance with the code might affect those, and therefore we want to take that into account. Now, it's important to remember that every variance that's granted creates a precedent. Now, anyone else who has the same or a very similar kind of situation would be able to obtain the same relief from the requirements of zoning based upon the precedent that gets set when a variance is granted, which is why variances need to be very carefully examined. A professor that I had when I was in college sort of explained it this way. You can consider a variance request sort of like a little hole punch, and you apply that hole punch to a provision in the code. And as you punch that hole, you've affected your ability to enforce that provision of the code. Punch the code often enough, and you're not left with a code to enforce anymore. It simply got too many holes in it. Now, public hearings. Variance requests, as Catherine pointed out, are considered quasi-judicial in nature and are specifically by zoning code left to the Board of Adjustment to consider. This consideration occurs as part of a public hearing. In order to have proper notice to conduct a public hearing in front of the Board of Adjustment, the following must have occurred, and this is specified in section 17.36.060B of the city's zoning code. Notice of hearing must be published in a newspaper of local circulation, which in our case is Daily Record, at least 10 days prior to the hearing date. Written notice must be mailed to all property owners whose parcels are immediately adjacent to the property under consideration for a variance, again at least 10 days prior to the hearing. And in this case, when we talk about immediately adjacent, we collapse things like open space areas and rights of way for streets or alleys. If you subtract those, if you collapse those, any parcel that touches the parcel that's under question gets a notice. And the reason we do this is jurisdictional. Adequate public notice is required for the local government jurisdiction to have the authority to act on it. If the public has not been given adequate notice of a variance request, that a variance request is to be considered by the Board of Adjustment, then the Board of Adjustment cannot act on the public hearing. It's a matter of, okay, if the people who are potential stakeholders in the outcome of this decision aren't given the proper time to arrange their affairs, to get to the hearing, speak against or for the project, then at that point, the matter can't go forward because those stakeholders haven't been given that opportunity. That's what I mean by the jurisdictional component to this. Now, when you are conducting a public hearing from the dais as part of, or I guess, electronic telecommunications, while we were under COVID restrictions, it is fair to consider the following as part of a public hearing. Variance criteria as defined in section 17.36.040E of the code, and I will usually include those considerations as part of my staff report to the Board of Adjustment. Advice from regulatory documents such as the zoning code or the subdivision and site plan development requirements. Points raised by members of the public either for or against the application. The quality of the proposal and how well or not it answers questions and depicts the applicant's case for hardship. The applicant's proposal in context to surrounding land uses, lot configurations, and building. The impact of the proposed variance upon the rest of the neighborhood and whether it would create conflicts. And finally, whether adequate public notice has been given for the hearing. What is not fair to consider as part of a public hearing is money spent in preparation of the application materials or in advocacy either for or against. This is not just by the applicant, it's by anyone who wishes to come and speak. If they're against it and they've hired some PR firm to give a slick presentation, the fact that they spent a lot of money is not relevant to the merits of the variance application. claims of a property owner sovereignty. And in this case, that means property owner who comes before the board and says, this is my property, I ought to be able to do with it whatever I want. Who do you think you are to impose zoning on me? Catherine can tell you that there is a century of law that's been established as zoning is in fact a valid expression of a community's police powers for protection of public health, safety, and welfare. They have been consistently upheld by not only appellate courts, but by the Supreme Court as well. And property owner sovereignty is not an excuse to say, I ought to be able to violate zoning. The applicant's time spent in Canyon City prior to submitting the application. The fact that they may be relatively new to Canyon City should have no basis of bearing at all on the merits of the hardship case. Personal feelings about the applicant, the consultant, or the neighborhood or district where the project is being proposed. If it's in an area of town you like to avoid because you find it to be relatively crime-prone, that should not affect your decision on the merits of the hardship case for the application. In quasi-judicial matters, personal like or dislike of a project is not relevant. What matters is whether the project can be found to meet the criteria for approval. Now, with that, at the conclusion of a public hearing, there are some things that need to have occurred. The Board of Adjustment is the decision-making body for a variance. This is a little different than the way Planning Commission handles things. Planning Commission is normally sort of the screen, the filter for items that will be going on to council for approval. Here with the Board of Adjustment, the decisions of the board is final, and there is no appeal to a Board of Adjustment decision within the city. The only option that a landowner who's been denied a variance has is to go to the courts, which is why, again, you want to make sure you're using city email, city-provided email accounts when we're corresponding or discussing things related to a variance case. The Board of Adjustment has 4 options when it's considering how to dispose of a project following a public hearing. Those 4 options are continuance, approval, approval with conditions, or denial. Citing findings of fact in a variance decision is extremely important. Not only do these provide context to the decision, they can help limit the precedent being set in the case of an approval or a conditional approval. They are also very important for another reason that I believe Catherine could elaborate on, and that is if a decision of the board is challenged and it has to go to a court, most courts are loath to put themselves in the process of making, or in the position to having to walk themselves through the decision-making process that the decision-making body went through. If they have adequate findings of fact, they're not going to second-guess what the Board of Adjustment did. They're generally going to say, it looks to me like the findings of fact are fairly conclusive, and they will leave it at that. And then ideally, granting variances should be rare and should only be based on the specific hardship conditions that may exist on a parcel. Variances are not meant to broadly modify zoning jurisdiction-wide. That would in fact be a legislative action. So for example, in the most recent variance case that we had, the applicant was asking for the ability to have what amounted to a 15-foot front yard setback as opposed to a 20-foot without a hardship exemption or a hardship case that he demonstrated. If that had been granted, the precedent that would have sent would have been a de facto rezoning for everyone within an R2 parcel. At that point, we would have had no ability to enforce a 25-foot front yard setback. That's why it's so important to evaluate these things carefully. Now, that concludes the staff presentation. I'm always certainly here to answer any questions that you may have. And I'm guessing Catherine may have some follow-up comments to my presentation as well. But again, let me underscore a point Catherine made. I am here as the resource for the Board of Adjustment to answer questions, clarify matters, see what I can do to get you answers to issues that are bothering you about the merits of a particular case. I am your resource. Please feel free to call me or email me with any questions that you may have, and I'm more than happy to spend time walking you through it.
Okay, thank you for that information. I have one question. You say that granting a variance creates a precedent,
Yeah.
but if we accept one, let's say with this guy on Candlewood, if we accepted that and then his neighbor wanted to do the same thing and we said, no, one's enough, we would be able to make that decision, and his only legal recourse then would be to go to court. So, I mean, I see how it establishes a precedent, but how are we beholden to the precedent that we set, I guess, is the question I'm trying to ask.
Well, that would be a case of being inconsistent. If the gentleman on Candlewood, whose variance request was denied, if it had been approved, and then his next door neighbor came in and wanted the same sort of 10-foot relief from the 25-foot front yard setback, there would be no grounds upon which to deny it because the precedent was already there. If it was denied anyway, he would go to court and say that the decision of the Board of Adjustment was arbitrary and capricious given its previous actions, and we'd be hard put to defend it at that point.
Patrick, it's Randy here. What if, remember we kept asking him if there was a hardship, which he could not present. If he did have some sort of handicap or something that, which, it actually would have helped him as far as his ramp or something like that, and then we allowed him, that wouldn't have set a precedent for the rest of the people along that block unless they had the same typical handicap, would it? Could we?
Well, a physical disability is not necessarily grounds for a hardship, and I hate to sound very cold and clinical about it, but what you're looking at when you're considering relief from zoning, someone saying I've got a hardship, that's something physical about the nature of the property itself. The fact that the owner of the property may be in a wheelchair doesn't necessarily enter into that consideration. Now, obviously, if they're wanting to make ADA compliances, ramps that go up to their front door, we certainly take a look at that. And in most cases, things like a ramp are not considered a built structure like a front porch with a roof on top of it would be.
Right. Yeah, that's obviously why we did not approve him, because he could not present a hardship.
Exactly, and I get what his planning representative was. He was making an argument that this was all done in the 80s and many things have changed since then. But again, that was kind of a specious argument because, fine, all of the lots that got built in the 1980s were built according to the setback requirements of the R2 zone, and they weren't built with, by that home builder, a front porch.
If I can for a second, I think you avoid the whole precedent issue if you really hone in on the facts of the application in front of you, because no applications are going to be identical. And so, or I've never seen it in over a decade of doing this. I've never seen two identical applications. So the precedent argument always fails, in my opinion, because applications aren't the same. And if you make a good decision, whether it's an approval or denial on the first one, and like Patrick said, you really lay out your findings of facts, and the next person comes in, the neighbor or whatever, and says, well, it's precedent, you approve this one, and you can be like, nope, this is how all these things are different, prove your case. And then you don't even reach that precedent issue because you can just show them all the differences. You did a really good job on the first one. So the findings of facts are really important. And Patrick mentioned, a judicial review of your decisions, and the threshold for us defending you is low. The standard is any competent evidence in the record. And so, but the more competent evidence we have, the easier it is. So we don't want to keep you at that minimum standard. We want to do the full, kitchen sink of findings of fact. So we have a bunch of competent evidence to defend the city's decision on. And so the threshold is low, but we like to keep those findings of facts as detailed as possible for a variety of reasons.
Okay, is that the end of our presentation, Patrick?
That is the end of my presentation, and that's the end of the training session that we put together. Again, if you don't have questions, then I would say that we could probably end the meeting.
I did.
So let me make the offer. Do you have any questions?
I did. Well, I'd like to make a kind of an amendment to the record, sort of. I kind of identified as myself as the vice chairman, which I'm not, because I was thinking planning commission for some reason. So I got my actual whatever you call it, positions mixed up. So
that's okay. We don't actually have the chairman or the vice chairman present with us today, and since we're not doing public hearing, I don't know that really matters.
I know. So, and one other thing, if I could bring up my email, not my email, but my information on the websites, both planning and board, are still expired, and positions are wrong. Would I see Elijah for that too, or how can I correct the website?
Well, I'll tell you what. If you can send me an email telling me what pages you're looking at where that information is shown, I can have our public information officer, Christy Gotham, make those corrections.
Okay.
It's probably just a case of I haven't sent her an updated roster of membership for either planning commission or board. It's undoubtedly my fault.
That's okay. I'm about 5 months expired. So.
I update these annually, and I probably just neglected to get her the updated list, so I can take care of that.
All right. Well, there's no other issues or anything, no other questions. Catherine, you okay?
I am okay.
Well, I would say that our training meeting is adjourned if nobody has any other questions or concerns. All right.
Well, everyone, thank you very much. I appreciate your time and attention.
Thank you.
Thank you, Patrick.
Thank you.
Always
Thank you,
a good
Catherine.
presentation.